Just in the next. Okay. Hi, everybody. We're going to just wait a minute or two to give everybody a chance to log in, and then we'll get started. So I think Jen and Peter, let's go another minute, and then we can get going. How does that sound?
Sounds good to me.
Works for me.
Right. Yeah, because you can, if you look at the tally, the numbers are starting to obviously go up as far as people who are joining. So we usually give everybody a couple of minutes so that everybody has a chance to hear the whole presentation and watch it. I have to kind of peek under my camera to see the number count. So hi, everybody. If you've just joined, we're about 30 seconds away or so before we start. We're just giving everybody a chance to log in. So we'll be kicking it off momentarily. All right. So let's start. So I'm Tom Ellsworth, and I'm joined by my partner, Jen Barnett, and also Peter Byrne from the engineering firm CCA. Thanks for joining us today. We really appreciate it. We very much enjoy doing these webinars, and we hope that the information is useful to you. So as you obviously know, today's webinar is about construction defect lawsuits. Considerations before, during, and after litigation. Jen and I are partners at Marcus, Rico, Emmer, and Brooks, MEEB. And as I'm sure most of you already know, we are a full-service condominium firm. We do everything that is condominium related. Jen and I are litigators, which means we're two of the, among the two lawyers on our litigation team that we take cases to court when litigation is necessary, and we also defend our condominium clients when there is a lawsuit brought against them. So Jen and I, and Peter as well, because we asked Peter to join, thought it would be an interesting and a good topic to talk about construction defect lawsuits. Jen and I do these cases. Peter works with our firm on a number of these cases, along with some other, and we also work with other engineering firms, but I've gotten to know Peter pretty well over the last several years and very much appreciate his participation today. I think you're going to find it really helpful. So Jen and Peter, any other opening remarks before we get into the presentation?
I don't think so.
I don't have anything. I know we're going to cover a lot of material today, so
We are.
I think we should maybe want to just say at the outset, if anybody has any follow-up questions at the end, or you want to reach out to Tom, myself, or Peter after the presentation with any follow-up questions, whether it be today, tomorrow, or anytime. Our emails are available on the next slide.
Yeah, and I'll be controlling the slides, Jen, so so that you don't have to worry. I say that, and of course now I stalled. So I'll be turning the pages. So that's a good point. Also, if you have any questions for us today, you're more than welcome to ask. You type them in the chat room, and then at the end of the presentation, which will be about an hour, we'll answer your questions today to the extent we can. So feel free to put questions in the chat room. I also have a couple of questions that were sent to us before we started today, so we'll answer those as well. So with that in mind, Jen, I think you're up first, and here we go.
Okay, so the first step in the process is everybody buys you know, a house or home, a condo, townhouse, whatever it is, no one necessarily buys it with the expectation that there's going to be an issue or that something's going to go wrong. And especially when you buy new construction, many people go into it thinking that this is brand new, you know, everything's perfect. This is, you know, oftentimes at the very initial stages of a development, the developer will still have control over the project. The developer will still maintain a presence. Oftentimes, the developer will have their own trustee appointed, which Tom and I often refer to as a developer appointed trustee, to operate and manage the association. The association or the developer might also have their own construction company involved, management company. And so it's at the stage, at the initial stage when everybody's buying in and everything seems great, a lot of it's because the developer is still in control. After a period of time, the developer is expected to turn over the association from developer control to unit owner control. And in Massachusetts, that time is governed by the association's governing documents. So if it says the developer is going to develop, you know, 100 units within 5 years, that 5 years is going to be you're going to use that as a time that the developer would turn over the association or is expected to turn over the association. It could also say that each association's governing documents might be different. However, it could say that when 25% of the units are sold, the developer is going to turn over control. The developer is going to turn over control after, you know, X number of units are sold. So you have to look at the governing documents. There's no statute governing the timeline that the developer has to turn over the association to unit owner control in Massachusetts. And many times the developer will set up what's called a single purpose entity. So say One Main Street LLC, and the sole asset of the developer will be that One Main Street LLC. So once all the units are sold, the developer no longer has, for lack of a better phrase, skin in the game. And usually they hold on right until that last point to turn over control of the association. If there's no timeline in the documents, and say, for example, the documents are silent, the developer simply says, I'm going to develop 100 units in multiple phases, but there's no timeline. The general rule is to look at the marketing phase, the expiration of the turnover or the phasing rights turnover event. You look toward the marketing phase. And what that means is that when does the developer stop actively marketing and selling units for sale? Is the developer, you know, still pulling permits? Have all those permits expired? And these dates are important because the association's rights and ability to act are really premised upon having control of the association. And so long as the developer holds on, the developer is obviously not going to bring a lawsuit against themselves. Well, I shouldn't say obviously. It's unexpected for the developer to bring a lawsuit against themselves. So it's that turnover event is really very, very important. I understand, you know, people don't want to jump into litigation. People don't want to don't want to get in a battle with the developer. Many times people have spent all of their, you know, their money to buy their home. And the thought of having to spend more money chasing the developer or engaged in a lawsuit just isn't, you know, very palatable to a lot of people. In New Hampshire, the turnover event in a traditional condo, it's 2 years from the creation or sale of 60% of the units, whichever comes first. There's different types of condos in New Hampshire also. There's what's called the traditional condominium, a convertible land condominium. So that's a phased development, is 3 years from the creation of 60% of the units being sold, or 2 years after the units having been last marketed for sale, or 2 years after development rights were last used, whichever event comes first. And there's also what's called an expandable land condominium. And again, these are, phrases that I'm using, they're specific to the statute in New Hampshire. And if you have any follow-up questions, please reach out. But for purposes of an expandable land condominium in New Hampshire, again, this is phased. 5 years from the creation, or 60% of the units being sold, or 2 years after the units have last been marketed for sale, or the development rights have last been exercised, whatever event comes first. In New Hampshire, the statute does allow for an association's governing documents to set a shorter time frame, but absent language in the documents, the statute controls the time for turnover. And the New Hampshire Condominium Act also is a bit unlike Massachusetts in that it mandates unit owner participation on a declarant controlled board after 1/4 of the units have could potentially be created have been sold, and at least one member and no less than 25% of the board must be elected by unit owners. So this takes into account the issues of a developer retaining control over the entire association for too long and hanging on for too long. Once at half the units that could be developed have been sold, at least 50% of the board needs to be elected by unit owners other than the declarant. And you just have to be careful. I'm sure we'll touch upon this at some point also during this course of this presentation. Beware of attempts by the developer to stack the board with other people who are affiliated with the developer and who own units. The whole point of the statute, at least in New Hampshire, is to allow for unit owners to take control of the association and to provide a mechanism for that. Similar in Rhode Island, the declarant control terminates on the earlier of 60 days after the conveyance of 80% of the units, 2 years after the developer has ceased to offer units for sale. Again, that's the marketing phase of the project, or 2 years after any development right to add new units was last exercised. So a developer in Rhode Island might have development rights in perpetuity, but if they don't exercise them, then for 2 years, then there's a mechanism for the association of unit owners to take control. So similar to New Hampshire, Rhode Island, again, unlike Mass, mandates participation on a declarant controlled board, so that it's after 25% of the units have been sold or created, the board must have at least one unit owner member, and not less than 25% of the board needs to be comprised of unit owners other than the declarant. So if there's 4 members, at least one needs to be a unit owner. So that's not related to the declarant. And after 50% of the units have been sold, at least a third of the members elected by unit owners need to be on the board and beyond the declarant appointed trustees. So also in Rhode Island, the statute specifies that there needs to be at least a 3-member board, the majority of which needs to be unit owners. In Massachusetts, our statute, unlike New Hampshire and Rhode Island, is much older, and it's more of an enabling act, so that it allows a lot of flexibility to developers, but there is some issues. When that, Rhode Island and New Hampshire have attempted to address by setting these specific timelines. So why turnover was important? Obviously, turnover is important because it's control. It's control over the affairs, the operation, the management. And so a lot of times, while the developer has control of the books and records. The developer has control over the finances, contracts, and can enter into contracts that may be favorable to the developer, may be unfavorable to the association. The developer may reserve a number of parking spaces, for example, specific in reserve easements over these spaces after his or her development rights have expired, and that they're free. There's all sorts of different scenarios that a developer could insert for their benefit in these documents. The important, one, as I mentioned earlier, the most important, I think why turnover is so important, why you don't want to delay that event, is because of the concern that if there are defects or deficiencies, those are likely not going to be revealed in terms of or in terms of the books, records, financial records, until the developer turns over control. And at that point, the developer's assets, once they sell that last unit, if they're a single purpose entity, your assets are not, it's going to be difficult to recover against them for improprieties in terms of financial improprieties. Sometimes there's issues where the developer won't start paying condo fees until until units are sold. They have to, whereas in Massachusetts, the units, once they are phased into the condominium, that's when the obligation to start paying condo fees arises. Many times, Tom, and correct me if I'm wrong, but oftentimes I would say that once we get the books and records, it's revealed that the developer was not paying condo fees for the units that it owned prior to the time of sale. And so those funds, belong to the association, and that's a breach of the developer's fiduciary duty by failing to assess and collect common expenses. Another issue that we see is that sometimes there's a commingling of assets, so that the developer may use association funds to fund improvements such as roadway infrastructures or infrastructures that the developer was obligated by the town or city or whatever local permitting authority to include as part of the development, and those are paid for by the association. Contracts, if they're developer favorable or again, the association of unit owners won't necessarily know that information until the books and records are turned over to the association upon turnover. Obviously, under 183A, Section 10, unit owners have a right to review the books and records. But in my experience, and I've been doing this a while, developers are not going to necessarily turn over books and records that reveal any sort of wrongdoing or misfeasance on their part.
If I could just quickly make a point, Jen, it's not unusual in my conversations with unit owners who are about to be involved in that turnover process, where their initial reaction is they want the developer to stay on as trustee because naturally the unit owners think that once the developer is gone and is no longer a trustee, that developer sort of disappears and will no longer have obligations to the condominium. And that is, although we understand why that naturally is the reaction, it's actually quite the opposite is true. Jen has explained why we feel it's important that turnover event happen as early as possible. And That does not let the developer off the hook at all.
But usually, you know, Tom and I are litigators, and so we see the issues when things go wrong. Obviously, there's plenty of situations in which the developers have developed a beautiful property, there's no issues, or their issues are relatively minor. That's Tom and I don't get involved in those situations typically. Tom and I usually get involved when something goes awry. Obviously, there, you know, at the best case, our role is simply to help facilitate the execution of documents, trustee certificates, and, you know, and generally, and we don't have much involvement with the association for years to come. That's the best case scenario. More often, for Tom and I at least, it's when there's issues that are suspected at around the time of turnover, the developer is saying, I'll get to it, as they're also selling off their last units and getting out of Dodge. So the other issues that come up, sometimes the developers will set artificially low condo fees, and just to make the development more enticing to buyers. So that's something else you want to consider. Is the association adequately funded? Or is there going to be money for any money been set aside for reserves? Has is there adequate insurance on the property? Is there director and officers policy? Are there any pending claims? So the developer, if the developer is not, paying subs or people who work on the project, ultimately they're likely to come after the association at the end of all this. So these are all things you want to be aware of ideally before the actual turnover. So once the turnover event happens, the board does not have a whole lot of time. There's no grace period for getting up to speed. There's it's once the association of unit owners takes control, they're going to be charged with the responsibility to act in the best interest of the association. And sometimes that means having to, expend monies to investigate issues, to do an accounting, to determine what, if you have systemic leaks affecting a number of units in the association, it's more likely than not that it's a bigger issue than one unit getting a periodic leak. It's likely to be some sort of widespread issue that needs to be addressed, and it's not an excuse for that. Well, it was the developer's responsibility. Ultimately, it's going to fall on this new board to take control. That doesn't mean that there isn't potential recourse. It just means that the association can't point back to the developer to avoid fixing the issues. So again, I think one of the first steps, and especially for boards that may not have experience with, there's no one on the board with, construction background or a legal background. The first thing to do, I would say, is figure out what's common areas, what's unit owners' responsibility, and who's responsible for the maintenance and an operation of each. Make sure, review the condo budget. Are condos fees being assessed pursuant to the governing documents? Or sometimes they'll, especially if the units are each assigned a very similar percentage interest, are unit owners being assessed pursuant to their percentage interest? Or are they being assessed, equally across the board? And that, unless the documents specify that's, the condo fees are supposed to be assessed that way, they should be assessed pursuant to the percentage interest assigned in the master deed. So there could be issues with that. ideally, as I mentioned, you want to plan in advance. So you want to have a pre, pre-turnover board and and have almost an acting transition board or acting transition committee. There's different terminology used, but the idea is really prior to the actual turnover event, you want to start interviewing your team. You want to start figuring out what are the big issues here. Again, you have to assume that the developer is not going to be candid and forthcoming as to what defects or deficiencies he or she is aware of. They're not going to be forthcoming as to whether they've cut corners anywhere or whether or not they've done anything improper. So the transition committee, let's say, should try to get this as much information on its own as possible. I usually recommend starting with a public records request to the town or city, get the permits, find out what who is working on the project, what are there any open issues, and that information is available through a Freedom of Information Act by request. Often there's a nominal fee involved for assembling the documents or records, but that's a good start. If there's a management committee or management company, they might be willing to share the financials. If there's not, it may be difficult to get that information prior to the turnover event. I think that you want to, if you take one thing away from this, get you want your team in place at the time of transition. You want, if you engage an attorney, a property manager, I would say the attorney will help navigate the association, pointing out provisions in the governing documents. Governing documents are going to be available on through the registry and are a matter of public record. So get copies of those. Get in your attorney also is a good place to start, if not the management, a management company, because that attorney, you want to protect privilege over the next steps. And if you do decide to pursue litigation and you do decide to engage somebody like Peter, which you'll hear what the value there, at least there is an added layer of protection so that you're not giving the developer a playbook of issues that he can use to refute, or basically a guideline on how to defeat your claims. So I would recommend interviewing attorneys or property managers and relying on them to help guide the process. We've all, Peter, myself, Tom, we've done this for quite a number of years, and it's an overwhelming process for anyone who doesn't do this every day. And there's a lot to it. There's a lot of moving parts, and the biggest issue though is you're up against the gun for timing and in terms of getting things done. And there's not a lot of time that you can't wait. You can't wait if people's roofs are leaking, windows are leaking. They're all going to end, or you're not being properly funded. You want to have your team in place. You want to have people guiding you. If there's issues that can be addressed when the developer is still there, that is ideal. But the manager will review your operational issues. The attorneys will review your governing documents. If you do engage somebody like Peter, or an engineering, you have a reserve study or a survey done, and you don't engage an attorney, please do not share that report with unit owners. Do not share the report with the developer. If you do, any privilege attached to it is lost. And so oftentimes these reports are preliminary in nature. That's why if you have an attorney, we recommend that the report be sent from the engineer to the attorney, and then the attorney share it with the unit owners to add that extra layer of protection. The issue, I've had clients where the developer holds on longer than they should have. They've had an engineering report prepared and it outlines all the defects and deficiencies. And unfortunately, by the time the association takes control, the statute of limitations is expired for taking action. And if it had it makes it even worse by the fact that I guess the adding insult to injury is made even worse by the fact that they had all the information to take action. The developer had all the information to take action, but for the developers retaining control over the association, nothing happened, and the association of unit owners ultimately had to fund the work and repairs that needed to be done, and it was widespread. So, as I'm trying to just jump ahead so that because I know we're on time, but if that leads me into Peter and why the role of the engineer is so critical to the transition process.
Thanks, Jen. Peter, so you're up next. Why don't you tell everyone a little bit about your firm, and then your slides go through the process from an engineering standpoint.
Very good. Thanks, Jen. Thanks, Tom. Good afternoon, everyone. Obviously, my name is Peter Byrne. I am a president and senior engineer with CCA. Today, I've been asked to talk about some of the construction defect investigations and issues that condominium boards are occasionally faced with. As a brief introduction, we at CCA are experts on the built environment. We collaborate with construction attorneys, condominium associations, property management companies, insurance companies, banks, and others to resolve complex construction-related issues. CCA regularly conducts construction defect investigations, expert witness and litigation support, property condition assessments, cost estimating, project management, and other construction consulting services. We have a staff, a multidisciplinary staff of experts, including architects, construction experts, engineers, both structural, mechanical, and we have certified industrial hygienists, building consultants, cost estimators. For example, I am a licensed construction supervisor. I have a Title V inspector's license in the state of Massachusetts. I'm a professional engineer, a civil engineer with licenses in Massachusetts, New York, Vermont, and Oklahoma by happenstance. And I've got 30 years of construction and engineering experience. CCA has provided expert opinions at deposition and trial related to causation, cost allocations, responsibility allocations, cost of repairs, business interruption, losses. And it should also be noted that CCA, we have invaluable experience working on both sides of the aisle, so to speak, investigating problems, assessing properties, identifying deficiencies in support of complaints against contractors or developers, as well as understanding and responding to allegations against the contractor, and with the insight that comes with working on both sides. It comes into play now and again.
And I forgot to mention, and I should have, Peter, the promotional notice for this webinar said that one of your engineers, Gil, was going to be with us today, and instead we got the boss. We got Peter because Gil was called away on duty to something else.
I'm the pinch hitter, and yeah, so I came in here short notice, but I know a thing or two because I've seen a thing or two, so to speak. So in essence, CCA we are a single source provider with over 35 years of experience, as you saw in the logo earlier. We are your one-stop source for architectural engineering and construction experts and we have the experience and capabilities to solve these complex problems. So let's talk about two aspects of what CCA does, as we're here on this first slide, and they relate to forensic engineering and construction litigation and related support. These two aspects of what we do are certainly related and potentially involve other scopes of service that CCA offers. With respect to the forensic engineering, which the dictionary definition of the term, it involves some attorney that will get involved in investigation of construction defects, as we're talking about right here, right now, but water intrusion investigation as it relates to potential defects, performing invasive inspections, coordinating and undertaking water and air infiltration testing and related diagnostic testing, building studies, property condition assessments, and variations of them. If it's less of an overarching property condition versus maybe it's an envelope assessment that just needs to be done, we can certainly trim down the extent of that scope. As I mentioned, we have cost estimators on staff. Some of the forensic engineering that we do also relates to cause and origin studies, product investigations, and then segueing into construction litigation, we will be involved with supporting all different types of dispute resolution processes, including litigation. We will get involved with identifying roles and responsibilities of the different players on a particular project, and any cost allocations that need to be identified, so that the different parties might be able to come to the table, so to speak. We'll look into material research and identifying defects associated with that.
I'm sorry, Peter, I see one question here about, the question is whether or not your role is just for new construction. What we're talking about today extends and is applicable to any type of construction being done at the association. Oftentimes it's the developer, and I know there was another question about declarant, but as Peter was mentioning, the water intrusion studies, these can happen at any point in time, long after the developer is gone. It could be done by, someone unrelated, by a different contractor entirely. And
Sure.
And if I could just jump in, when Jen and I see that, we have cases where we defend condominium boards where a lawsuit has been filed by a unit owner under allegations that the board failed to properly maintain the building, and usually, not always, but usually that's windows that leak. And so yes, in those circumstances, we also would absolutely recommend to the clients that an engineer be hired to investigate and help resolve that issue.
The board's going to be judged by, in Massachusetts, what's called the business judgment and rule, and that's the general rule that's applied in reviewing a board's decisions. What information did the board know at the time, and were their subsequent actions reasonable? If the board hires an engineering company upon being alerted to ongoing leaks or issues that are beyond the scope of its knowledge, and it relies on then acts pursuant to that expert advice, that would be, that's oftentimes considered reasonable. Is it always? No, but the general rule is, if the issue is beyond the scope of just general knowledge, hire the experts. It's worth it. It's Peter has it, and individuals like Peter have such extensive knowledge and access to resources that a board on its own, which is made up again of volunteers, is not necessarily going to be aware of on its own.
With respect to the transition process, as it relates to taking ownership control from the developer, and some aspects of that, I know that there's a term transition study that's been talked about, and in fact, in a prior slide, I saw a reserve study as well. It's worth clarifying that the CCA typically will perform a property condition assessment as it relates to in support of these studies. Whereas a reserve study is somewhat of a financial planning exercise, it's very important, and you tend to have more of an accurate financial accounting if the repair scopes and cost considerations are developed by a construction expert versus a financial advisor. And so that where that comes into play is the property condition assessment that can identify those issues as well as potentially cost related to some of those issues. And that can in turn be provided to the financial advisor that can flesh out the rest of the reserve study based on that information. Similarly, there's no industry standard or definition associated with a transition study, so to speak. Whereas the property condition assessment, in fact, I haven't noted there is a standard. It's the ASTM 2018, and we use this as a basis in support of the transition analysis, such that we're all aware of what we're getting. It's not a term that's, like I said, undefined. It is defined, and as a PCA or property condition assessment, as a series of steps that are outlined in that ASTM guideline, and which at the culmination of things produces a property condition report that could potentially identify next steps and recommendations, and as I mentioned, possibly cost considerations related to that.
And Peter, since I'm in control of the slides, and if I'm not advancing when you want me to, just tell me when you want the next slide. Just say next slide and I'll do it.
Very good. Next slide.
All right, there you go.
So as part of this, and we approach some of these matters, we kind of follow a similar proven process during the course of things, and it's one is to recognize the problem, what it is we're dealing with. Is it a transition in support of a transition process? Is there are we aware of issues straight away? For example, sometimes there is some indication that all things aren't right, and so we can certainly account for that as part of our initial discussions. There's a CCA consultation and engagement, and at which time we can confirm deliverables, establish a CCA project plan, and estimate the project budget associated with CCA services. In many cases, we might recommend an initial triage phase and budget, which is in essence kind of first initial understanding of things. It typically might entail a document review, a site visit, and perhaps verbal reporting, and then identification of the next steps after that, which could be potentially follow-up site inspection, and maybe there's invasives, maybe there's testing that we want to do at that point. But that's possibly one way of approaching it. The investigation and analysis, as I mentioned, site visit, review of documents, review of standards, sorts of information gathering and research associated with that. There's a reporting aspect of everything that we do, and potentially that segues into some dispute resolution and testimony and litigation and support and testimony. Next slide. Thank you. So digging in a little bit more into the investigation and analysis efforts, the first is review all information and pertinent information that's available. That might include contracts and plans and specifications, public offering statements, to establish an initial understanding of the property and the project, and identify parties and roles and responsibilities as needed. In some cases, due to the extent of documents, we may develop a detailed searchable document index that allows us to kind of identify straight away some key documents and begin to kind of organize them as needed for our analysis. Let's see. We'll use available documents to further refine site inspection planning. For example, as I mentioned, the public offering statement, in a lot of cases, we will want to confirm common areas that are to be examined, if that is in fact the extent of what we need to look at. Whether windows are common elements has come into play now and again. Balconies, another kind of aspect, but we need to understand what those are and how those kind of come into play. Perhaps there's representative sampling that needs to be done, or property access and coordination relative to performing that site inspection, which gets us to the site inspection itself. The initial CCA's initial inspection is typically visual observation only. This is in accordance with the PCA process as identified, as outlined in ASTM. Some non-invasive testing might be performed at that time. Use of non-destructive moisture meters, infrared camera surveys. Perhaps we want to engage a drone survey because we can't get access to the roof or some of the upper reaches of the building. Use of boroscopes might be possible as well to see inside building assemblies without tearing them apart. Also, as I mentioned before, CCA is a multidisciplinary company with different expertise with respect to the property condition assessments. CCA's inspection may involve other disciplines to capture the conditions associated with the different systems. Mechanical engineer might be present during the course of the inspection to outline all the conditions associated with the rooftop equipment, for example. There's a structural engineer that typically gets involved to inspect framing and foundations and what have you. There's building envelope experts. There's other experts that are on staff that are available to assist in these property condition assessments, so that you're able to capture from an expert's viewpoint all the issues associated with the property. As identified previously, and consistent with the ASTM process, the initial assessment may require a follow-up inspection. That might be a recommendation for a next step, and the follow-up inspection may involve invasive sampling, destructive testing, what have you, just to further root down on some of these issues. Additional information gathering might include on-site interviews, resident surveys and responses to those surveys, leak logs, review of maintenance records, perhaps a visit to the building department to go through what records they may have, if that's pertinent to our investigation. Research of product data, and perhaps research of weather records might also be germane to our investigation. Last bullet is probably one of the most important ones, and that is to confirm the basis for these deficiencies. Is it a code requirement? Is it something that the developer was obligated to provide as part of their contract or the public offering statement? Is the material installed in accordance with the manufacturer's recommendations? Or there's industry standards that are at play. All these things will help to kind of confirm, as we identify some of these issues, what the basis is for it actually being an issue. Next slide, Tom. So when we go through the investigation and the analysis, we begin to start to compile our findings. Typically, what we will do is put together a deficiency list or a conditions matrix, and that is exactly what you'd expect it to be. This is identifying the deficiency or defect, indicating its location, where it was found. Is it a pervasive issue, or is it a one-off at certain locations? That's important to know. Also, what is the damage? What is the effect of this defect? Is there consequential damage that's occurring because of the presence of this issue? And as I mentioned before, the corresponding basis associated with each one of these defects. Part of the reporting might involve development of the reasonable repair scopes and necessary for remediation of damages and rectifying of the defect itself. We will also typicily get involved in developing construction cost estimates for those repair scopes and remedial measures. This cost estimating is just kind of the first step in establishing the cost damages associated with what's happening. Obviously, the cost estimates will also need to account for the extent of consequential damage or the impact associated with the work, whether it involves perhaps moving out of the property in worst case scenario, or there's other issues involved. As I mentioned before, there's verbal reporting that occurs throughout the process through counsel, and ultimately a written report is generally identified and produced. That can be either a property condition report, which basically outlines the findings from our property condition assessment or building envelope assessment, whatever the case might be. It could be an expert report. It might be an expert disclosure, as counsel needs in order to kind of continue the process. Also, the written report may very well, or the verbal report, identify what the next steps might be and where this process is going to take us. Next slide, Tom. As it relates to next steps, and as previously discussed, following the investigation, analysis, and reporting, CCA can provide support to litigation or other dispute resolution processes. In addition, there are other means that CCA can support the project following our investigation. For example, the repair phase. And one aspect of that is potentially working with the contractor, the developer, if they're willing to, if they're amenable to that, to evaluate what the issues are, confirm a mutually agreeable repair scope, and things can kind of segue from there. We'll talk about what that means in just a moment. Another aspect is to recognize that in some cases the dispute resolution process might take a while, and there are issues that need to be addressed sooner rather than later. And CCA can assist with that, with developing bid documents or any other set of information such that a contractor can be solicited and engaged to not only produce a cost of repair associated with the rectifying the issue, which again gets us back to a damages aspect of that, also to actually perform the work and rectify the issue, perhaps mitigating any consequential damage that's still occurring. And that's certainly one way that CCA can help in advancing things. OPM and construction administration services relate to whether an outside contractor is doing the work or the original developer has come to the table and going to perform the work. And these types of services involve periodic inspection of the work as it is being remediated and put in place to ensure that it conforms with perhaps not only the plans and specs that CCA may have developed, but it's in accordance with manufacturer's recommendations for installation. So we want to make sure that that's in place, and that construction administration aspect of what CCA does kind of brings some peace of mind to ensure that the fix is proper. We can review contractor costs or payment applications related to the work, and typically will also be involved in any punch list related aspects and run that process so that at the end of the day, everything is as expected. And last but not least, we certainly are involved in support of the dispute resolution and litigation, and providing expert testimony as needed, demonstrable exhibits, and what comes out of that.
And I hate to interrupt you, Tom, because I know you're next. I know it's 12:55. This is supposed to end at 1. We'll be available. We will answer all the questions if you want to hang around a little bit longer. I know that there's quite a bit of questions. We'll stay on as long as need be to respond. So if you are interested, please stick around.
Thanks, Jen. Yeah, so that's always the hard part about going last, is that we never finish in an hour. But here goes, because I think this is really important. Now, just assume that the transition has happened. Now the unit owners are in control of the board, of the condominium board, and you've hired an attorney, and you've gone forward with an engineer, and you at least have some understanding of what the problems are with the building. Let me point out at the outset, what we're talking about with a construction defects case or a claim against the developer, it's about common area. So, for example, if unit owners, even if all the unit owners have problems with their cabinets or their flooring or with light fixtures in their unit, that's not what this is about, because the boards who are in control of the condominium associations don't have authority to bring claims on behalf of unit owners for construction defects to the unit elements. We're talking about common area defects. And that usually means, of course, the building envelope. Oftentimes it means windows, not always, and you have to check the condo docs. And just generally any element that's considered common area. That's what we're talking about today. So, of course, at the end of construction, every building's going to have some kind of an issue. Oftentimes, it's just simple punch list items that really aren't worthy of a lawsuit, but just are issues that need to be addressed by the developer to finish the project out. And that's not unusual, and we got a lot of cooperation with those kinds of things. But when Jen and I, when we have lawsuits involving construction defects, those are usually the big ticket items, the ones that are very expensive to repair, and where the developer is not coming forward and offering to pay for that work or to do that work. So note that the defects and deficiency in a condo building, they have to be addressed. And so it's not, the condo board isn't not in a position to say, well, these problems were caused by the developer and the contractors who worked on the building, so we're just going to push it off for another day, or hopefully they'll do something. The trustees have a fiduciary, and the trustees are board members, and if it's not a condominium trust, the condominium board members have a duty to address the issues. That one way to address them is to just fix the issues and have the condominium association pay for it. Another way to address it is to go into litigation, and that's we're going to talk about that. There are implications for failing to perform the work. One that we mentioned on the slide here is that if the work isn't repaired and that leads to issues down the road where there could be a really expensive assessment, and I've seen this in a couple condos where it's just extensive, widespread, usually water damage. That could lead to a situation where the association, where the condo was put on a blacklist by the lenders, by Fannie Mae. And what that means is that it would be very difficult, if not impossible, for someone who wants to buy a unit to get funding. So that's one impact. Another impact that's not on the slide, which I do see and Jen sees, if the building is not maintained by the board, unit owners can and might and often do sue the association for failure to maintain. And where this usually comes up is where it's a roof or a window, there are substantial water leaks causing damage to a unit. So, and those can be very difficult cases. So that's another real serious implication for failing to maintain the building. So one thing is, we often try to work with the developer to try to see what they are willing to do, right? One important thing, and this does happen, where we'll have a developer say, I'll come in and fix all the issues, but first, before I do that, the association has to sign a legal release releasing us from all claims. Sometimes we see it happen before we're consulted with, and that's too bad. That's definitely something to avoid for obvious reasons. Next, unless there's an emergency, and sometimes that happens, but unless there's an emergency, it's important to give the developer notice that repairs are being made or that invasive investigations by an engineer or some other professional is going to happen. And the reason is that if it goes to litigation, you don't want to be in a position where the developer says, well, they opened up the walls, they made all these changes, and so they've effectively, they meaning the association, have destroyed evidence. So it's important to make sure that the developers have notice of any repairs or any what we call invasive testing, where walls are opened up, where windows are taken apart, that kind of thing. And we do that. There'll be a site visit where we invite the developer and the developer's engineer, whoever the developer wants to bring, to observe these processes so that we don't run into an issue down the road where it's claimed that the association destroyed evidence. It's important to know at the outset when considering repairs, and it's something that needs to be dealt with usually sooner rather than later. In most circumstances, unfortunately not all, especially for a very small condominium, but for most condominiums, you can get funding from a bank to pay for the engineering, the cost of the repairs, and even legal fees. And that's always a very, very important consideration up front, because ultimately what we're talking about today, what's in the back of the board members' minds and the property manager's mind, it's the money. And we're going to talk about that a little more in a minute. All of this stuff, of course, is hugely expensive, right? I mean, there's no two ways about it. And so an important consideration at the beginning is for the most part, most of the time, a condominium association can get funding, especially when the issues, the building defects issues have to do with water intrusion or any other health and safety issue. We are going to tell our clients that you have to go ahead and make those repairs and do it. You can't wait till the end of the lawsuit. You have a duty, we think, as board members, to do those repairs as soon as you can, especially when it has to do with water intrusion and when it has to do with any other life and safety issue. You can't wait. Also, in the course of a lawsuit, you have a duty to what's called mitigate damages. In other words, if you could have taken steps early on to stop the spread of the damage and you failed to do that, that actually is a defense that is available to a developer. So you have to act. We've put some bullet points on the slides of things that the bank's going to need in order to provide the funding. Those are important considerations that all have to be dealt with up front. Early in the process, at least start a conversation, and we help our clients do that with the lender. We introduce clients to lenders to try to get the money in place in order to make all these things happen. Next, one thing that has already been mentioned by Jen briefly, early on at the beginning, this is a very important consideration, and that is the statute of limitations, because when there are construction defects, the clock starts ticking right away. And so I'll tell you what I mean by that. But boards, in transition, when a unit owner controlled board takes control, this is one of the several reasons why it's important to address construction defects issues immediately, because the clock could be ticking. There's a 3-year statute of limitations in Massachusetts. It's 3 years in New Hampshire. It's a little more forgiving in Rhode Island, where it's 10 years. what does the limitation mean? So a question I often get is, well, if we send a letter to the developer saying you need to fix these construction defects, does that stop the clock running on the statute of limitations? And the answer is no. What stops the clock on a statute of limitations is filing a lawsuit. Nothing short of that. So when a developer says, yeah, we acknowledge there's a problem, we're going to fix it, we'll take care of it, we'll get to it, next year, even if the developer acknowledges that there's a problem and says that they'll fix it, that doesn't stop the clock from running. And we all have to be very careful about that. The statute of limitations is subject to what's called the discovery rule. The clock starts ticking on the date that you knew or should have known on the defects. If the building is leaking the day it opens in the first rainstorm, there is an argument to be made that the clock started ticking right away. You have to be real careful about that. So obviously a lot of construction defects aren't discovered until the engineer has completed the investigation, issues a report. And that's when you discover that I had this happen in one case, for example, that the roof beams, the structural members of the roof were undersized and the roof was starting to sag. So, and there are other latent defects that don't come up until later. Another case I had, for example, there were a series of private septic systems that there was no way to know that they were defective, but after a year, all of them started failing. So the 3-year statute of limitation in Massachusetts, that clock started when the board members learned that they were failing. So
But within that, right,
yeah.
there's also, within that statute of limitations, it's still subject to the statute of repose.
Yep, that's next, is the statute of repose. And this is, the statute of repose is something it's a simple concept, but it's sometimes difficult to explain. What the statute of repose means is that even though you have 3 years from the date that you knew or should have known in Massachusetts, 3 in New Hampshire and 10 in Rhode Island, there is still an outside limit, no matter when you discover it. Doesn't matter. So for example, in Massachusetts, it's 6 years. In New Hampshire, it's 8 years. In Rhode Island, it's 10 years. From the date the building is substantially complete. That's oversimplifying it, but for our purposes today, I think that's good enough. So if the building was finished in 2010, and then you have a turnover event where now the unit owners take control in 2017, and in 2018, you find out that the septic system is failing and it's defective. You're out of luck. You can't bring a lawsuit. That's the thing about the statute of repose, and it's always important to know when the building was substantially completed. The clock starts ticking on these statutes of repose then, regardless of when you find out about the defect. So let's just take Massachusetts as an example. 6-year statute of repose. The building is substantially complete, let's say in 2020. 5 years later, the board members, now that's it's the unit owner controlled board. 5 years later, finds out that the windows are defective. They start leaking after 5 years. Do you have 3 years to bring a claim under the discovery rule? No, you have 1 year. Because once that 6 years passes after the date of substantial completion, you're done. So it's really important to keep these dates in mind. So those statutes of limitation, those years only apply up to the deadline for the statute of repose. And so again, easy concept, sometimes a little difficult to explain, but that's why the golden rule is for condominium boards who've just finished the transition to unit owner control. You got to start dealing with these issues and looking into them immediately. we didn't put a lot of the claims in the slides that will be brought against the developers in a construction defects case. The big one is negligence. It's professional negligence. The good news for the associations is it's really one-stop shopping. You don't have to bring a lawsuit against all of the subs. Could be dozens of subcontractors. You don't even really have to bring the claim against the general contractor, although we often do. It's one-stop shopping. The association can bring the claim for construction defects only against the developer. And even if the developer didn't, have anybody within the development company actually pound nails and construct the building. And that's because the law recognizes that the developer has responsibility for everything. So it's not a defense when the developer gets sued. The developer doesn't get to say, I don't own the construction company. I don't, we hired subcontractors. It's their fault. Nope. The developer has responsibility for everyone. We do often, though, we also will bring into the lawsuit the general contractor, and that's because that automatically brings in another insurance company into the mix. It's not unusual for the developer and or the general contractor to turn around and bring into the lawsuit the subcontractors. That's okay. They can do that. That might even bring more insurance into the case, which we'll talk about in a minute, why that's important. But anyway, negligence is the big claim that we often bring in, we always bring in these cases. And the Consumer Protection Acts for these states also are often implicated. And so, I don't want to get into the weeds on that, but those are also Consumer Protection Act claims. We do bring those. What I did want to mention, though, and we prepared the slide for it, it's an interesting twist to these cases, and that is claims for breach of fiduciary duty. How is it that we get to do that, bring these claims? And that's because in just about every single condominium, when the condominium is created, the initial board member, in Massachusetts, it's the trustee. In the other states, it could be just a board, a director, doesn't have to be a trustee. The initial board member of the association is usually the developer. It used to be pretty frequent where it was the person who was in charge of the development company would be the initial board member. Now they're a little craftier, and they actually make the company the initial board member, which they can do. That's okay. They can do that. So that's almost every single condominium. When that happens, that board member, whether it be the principal of the company or the actual development company itself, they owe a fiduciary duty to the association. Just like all subsequent board members, a fiduciary duty is owed to the association. That creates a really strange dynamic because their fiduciary duty to the association has to come before their interests as the developer. And I guess what I'm telling you is that creates an inherent conflict. So it's not unusual for the developer to not deal with known defects at the beginning, soon after the building is created, because they don't want their company to have to spend the money to fix them. That's a conflict. And we believe, and we claim in these lawsuits, it's a breach of fiduciary duty because the developer is wearing the two hats, and by law, they're supposed to put the interests of the association before the interests of their development company. And I think you can understand why. That does not always happen. So that's in the construction defects context. There are also other breach of fiduciary duties. Jen's mentioned some of them when there's financial mismanagement, when they don't properly fund the reserve, or they don't, or sometimes they keep they can keep the fees artificially low because it makes the units more attractive. Sometimes, not always, that could lead to a breach of fiduciary duty claim. But what we're really talking about today is failure to understand, investigate, and repair building defects. In Massachusetts, there are a series of court decisions. They're from the trial courts, but nonetheless, there are court decisions that have ruled it is a valid claim by an association for breach of fiduciary duty against a developer for the developer's failure as a board member to understand, investigate, and repair building defects. So that's a pretty potent claim. And in New Hampshire and Rhode Island, a breach of fiduciary duty also brings with it the potential to get attorney's fees. In Massachusetts, when we bring these lawsuits, we turn to the Consumer Protection Act claim to try to recover attorney's fees. There are other claims just quickly worth mentioning. Warranty claims. By statute, they're available in New Hampshire and Rhode Island, not Massachusetts. In Massachusetts, we have the implied warranty of habitability. All of these here's a common misconception. I get this all the time from the board members. They'll say, well, we talked to the developer and he says he doesn't have to fix the windows because the 1-year warranty period's expired. That's just not how it works, folks. Oftentimes, there might even be a written warranty by a developer who will give a 1-year warranty. And then they often will try to hide behind that when they're asked to fix the problems. And they say, sorry, it's been more than a year. I get that a lot. I hear that a lot. And that is just not the case. One reason is all of those claims I talked about earlier, negligence, breach of fiduciary duty, breach of the Consumer Protection Act, all of those are not tied to warranty claims. They're independent, and it's not a defense of the developer to say the 1-year warranty period has expired. Also, in Massachusetts, for example, the breach of implied warranty of habitability, that has a life of its own that's not limited to the 1 year that a developer might try to impose. And that could be all kinds of things. That could be the windows leak, the building's not insulated properly. And it's a pretty broad implied warranty of habitability. It doesn't have to be so bad that you can't actually live there. It kind of sounds like that. But what it means is that the building is not fit for human habitation, but it doesn't mean that you can't literally be in the building. It's not what it means. We've got a note at the bottom about express indemnification. That doesn't often really apply to developers, but there is a tie-in that I'll talk about later. There is almost always an indemnification clause for board members. Sometimes developers try to hide behind that. We'll get into that in a couple of slides. Next, beware of diminishing returns. Be strategic in your approach. You have to act early. You just do. You can't wait. You know, if you wait until 3 years after you know as a board that there's a problem, that's clearly going to be a problem under the statute of limitations. You have to make decisions. And by the way, I have these discussions with boards so often. When there is a turnover of the board to the unit owners, and now suddenly you're a trustee, and the first thing you have to deal with is potentially, in some of our cases, a multi-million-dollar construction defect problem. That is not what you signed up for. It's hard. And then, you know, you're not only dealing with the fact in many cases where your building is actively leaking water, now you have to deal with the financial aspect to it. It's tough. It's tough work, but it has to be done. And it has to be done early for all the reasons we talked about. You have to have realistic expectations. It's not unusual for us to tell these boards that there's no justice at the end of this road. It's highly unlikely that the association is going to end up being 100% whole, where the developer is going to pay for all the attorney fees, all the engineering fees, and all the construction costs. That's a tough pill to swallow, but that is a conversation we have early on. And that is, maybe with one exception in my career, That is not going to happen. What will almost always happen is that at the end of the road, you will get to a result you can live with. And oftentimes that's by choice in what Peter referred to as dispute resolution, in mediation. And so that's usually how they resolve. And always we're looking for leverage, and we'll talk about that in a little bit, looking for leverage to try to get the developer to do the right thing, to fix issues, to pay money. Leverage is a big part of the strategy. Here we go, litigation, costs and unpredictability. Before we started, we had an email question. How much does it cost to litigate one of these cases? It varies depending on how serious the problems are, because the bigger the problems, the more expert. These are expert witness cases, by the way. You just can't get on the stand as a board member and say the windows leak. That can't prove, that's not enough to prove a case. It's required that experts testify. So the bigger the problems, the more expensive the case is, the longer the case takes to resolve. I will tell you, it's not unusual for the fees to take these cases through a trial. If they don't settle, it could be well over $200,000. And I will tell you, that's our rates that we charge in the condominium world. Those are not Boston law firm rates. So it's expensive. It is expensive. And that's why these considerations are so important early on. And that's the big cost benefit analysis that board members must do. And that's why you need to know what the problems are. You need an engineer to help you so that you can figure out what the scope of the problems are and how much it's going to cost to fix it. Because as board members, you have to weigh that cost of fixing the building against the cost of going forward with litigation. And, you know, it's a tough decision to make. If it's a $5 million problem to fix the building, that's an easier decision to make whether to go forward with a lawsuit. If it's a $50,000 problem to fix the building, it's actually a tougher decision to decide whether to spend the money to go forward. And those are the conversations we have with our clients. Ultimately, most of these cases do typically settle. Not always, though. You have to be prepared to go to trial. You don't, we would say you do not file a lawsuit with the idea that you're going to probably settle and you don't want to go to trial. That's not how it works, because you don't know at the beginning whether it's going to settle. Usually they do settle, not always. And settlement can include payment of money, corrective work, or payment of money and some work. And the reason why we put in a note that you have to be careful on the work is we want our engineer on site to observe the work that's done if there's corrective work done by a developer, to make sure that it's done right. And if it's done by agreement, it's only going to be done if it's done by agreement. Developer doesn't just get to come in and start working. The board has to agree. It's going to be with the approval of our expert. That's how that works. So the goal should be to achieve the best net result. As I said before, you can't go looking for justice in a civil lawsuit in America, not with these kinds of cases. What you're looking for is the best net result, one that you can live with, so that you can move on and move past the lawsuit. It's gonna, these lawsuits, even when they settle, it's gonna probably be at least a couple of years to get to the end. It's a big deal. You wanna get to the point where there's a resolution and move on. Get your building fixed and just enjoy living in your beautiful condominium. That's the goal. Tips for the unwary, just really quick. I'm not going to take a lot of time on these. We already talked about this. Sue every contractor and every sub who worked on the job. No, often not really any need to do that. So it's typically not what happens. What happens if it's a single purpose entity? And as Jen pointed out before, all the units are sold and the single purpose entity has no assets left. What do? Is there still hope for recovery? The answer is yes. oftentimes, almost all the time, not always, but almost always, these cases really are about insurance. And the developer and the GC on the job, they're going to have insurance. Almost always, there will be insurance on the other side. And so, does it help if the developer is a single purpose entity that still has some assets? Sure. But is it critical? No, not if the developer has insurance. Contingent fees, we don't do contingent fee. We do not do contingent fees in these kinds of cases, and there are important reasons why. You have to be careful about that. For one thing, if you look at the cost that it will be at the end of the case, the percentage that you have to pay a lawyer on a contingent fee, it's really expensive. Also, I just want to be really polite on how I say this. We think that the client should want a lawyer who is looking for as quick a resolution as possible. I think that's the best way to say it. And we feel that might not happen if there's a contingent fee relationship. Next, political unrest. Holy cow, this is another big one, and we deal with this often. Is it the case where if the building defects are really widespread and bad, and usually that's windows and roofs, is it possible that no one will be able to sell a unit until the building is fixed? Yeah, it happens. It's tough, but you still got to deal with it. And that's why, trying to get these issues on the table and out front and trying to get them resolved, even if it takes years with a lawsuit of several years, you got to do it. Just one quick war story. I had worked with a client who it was a condominium, 100 units in a brick building that used to be a leather tannery. Well, come to find out, all the units are sold. The property manager gets a letter from the Department of Environmental Protection, said, what are you going to do about the contaminated soil underneath your condominium building? And the developer knew about it, never disclosed it, and sold all the units and ran. We filed a lawsuit, and we got a very good result, and it was all resolved at the cost. It was paid for by the developer. But while that lawsuit was ongoing, there was 3 years where nobody could sell a unit. That can happen. It's a reality. It is what it is. Oftentimes, though, the defects are such that units can still be bought and sold. Do they have to be disclosed to the purchaser? Yeah, we would suggest that they do, of course. This is now, Jen, if you want to get into phase condominiums, there's a few slides.
So I was trying to answer the questions as I could. It didn't require a lot of in-depth response. So just so if everybody's aware, one of the questions was, are there cases where the building's been declared a lemon due to construction defects, repair costs being close to the original value?
How about this, Jen? If you don't mind, you're looking at the chats?
Yeah, because there's.
Do you still want to go through the screens, or do you just want to answer questions?
I think answering questions, because a lot of them are going to get answered. I answered 3 so far, just with reference to the statute.
All right, I'm going to stop the screen share then.
There's no specific statute or provision in the statute by which in Massachusetts, in which a building could be declared a lemon due to construction defects alone. However, under 183A, Section 17, there is the provisions provide a framework for proceeding if there's a loss or casualty that exceeds where the costs of repairs are going to exceed 10% of the condominium prior to the casualty. As far as this does have a tie back though to construction defects if the project didn't meet code, and the cost of repairs, a lot of times they're code upgrades. So the law and ordinance cover, if there's no law and ordinance coverage, those costs of the code upgrades can be very significant. So if it doesn't tie directly to construction defects, but there is that mechanism under 183A, Section 17. The other question was if we could define the term declarant. As I mentioned at the outset, 183 condominiums in Massachusetts are a statutory form of ownership. Term declarant is used in the 183A Section 1. Essentially, it's the person or entity that's referenced in the master deed as submitting the land and the improvements to the provisions of 183A and thereby establishing X condominium. And then I provided
And
Peter's
if you don't mind,
contact.
you
Yeah,
know, people are starting to drop off. I'm gonna just buzz through some of these questions if you don't.
sure.
Is that okay? We've got a number of questions about the 6-year statute of repose. The answer to all of your questions are no. There's no way around it. Doesn't matter what the developer did or did not do. Once the building is 6 years after substantial completion, you are out of luck. What are your recourses after that? You fix the building yourself and there's no claim against the developer. It
But-
doesn't, yeah, go ahead, Jen.
Sorry, but I know we skipped the phase development. The 6-year statute of repose is from the date of substantial completion. So in multi-phase developments, there might be the statute of repose might be different for each phase.
That's right. There was a recent court decision in Massachusetts that said it's building by building. So if you have 6 buildings and each one was completed at a different time, the 6 years starts a different clock for each building. So thank you. That's important to know. Let me just buzz through a couple of these. Yeah, what recourse, we already talked about that. If you don't discover the defect till after the 6-year period, you're out of luck. You have no claim. You still have to fix it, but you can't file a lawsuit against the developer. You could try, but if there's a 6-year statute, if there's a 6-year period, you're going to be out of luck.
But you might be able to pursue claims under a breach of contract, a breach of third-party beneficiary contract. There is a potential for that in.
There's a potential. And it might be more of a potential in one of the states than others, but it's going to be tough. It's
right.
going to be.
But just going to in terms of, I'm just looking at, that was the next question. I believe it's after the LLC. If the construction defect judgment beyond the assets of the LLC, so the developer might not have a lot of assets, or the developer may have assets, but the LLC may not. In that situation, if there's a commingling of funds between the LLC and the developer, that could provide a mechanism by which to quote unquote pierce the corporate veil. That's difficult. In that more often we would look to see if there's any design professionals, architects, engineers, plumbers, electricians. And again, I mentioned before, those names and the identity of those individuals can be easily obtained just by public records requests oftentimes. So it's worth it to go through that exercise. That's for purposes of the statute of limitations, statute of repose. Tom mentioned that you have to file a lawsuit. You have to file a lawsuit against the right people. So if you don't name everybody, the right individuals or properly identify the proper defendants at the time of when the statute of repose, statute of limitations expires, you can't go back.
Mm-hmm.
All right, and then I'm just going to try to get a couple of these out of the way. Should a title examination be done to ensure title is clear from any developer mortgage liens? When you buy your unit, your bank should do that. But the thing here is an interesting question. Gosh, I'll try not to get into the weeds. You can't someone with a lien on the condominium property can't foreclose on the condominium. You just can't do it. So is it a concern? Sometimes it crops up, but for the most part, the developer is required to turn the condominium owner over to the unit owners free of encumbrances. Concern about a small LLC with nothing at turnover. Do you see an opportunity for success for a small group of owners to take action against builder before turnover? Yes, it's possible. If there's a problem that's obvious before the turnover and the unit and the developer isn't taking care of, like the windows are leaking, there is a mechanism under the law. It's called a derivative suit, where the unit owners can band together and file a lawsuit effectively on behalf of the association. So there is an opportunity there, and that's something to talk to your lawyer about. Jen, are you seeing anything else while I scroll through these?
Let's see. So, Dave Abel, he wrote that there's one, numerous development litigations. There's a developer who agreed to hire an engineer to be proactive. That is the best case scenario. Obviously, you know, they're not going to, they run the risk of, you know, having to do work, but it also, they're more likely than not going to do everything on the list. But I think that at least it provides, if nothing else, it provides the successor board with a framework for proceeding. And so even if it's not the full scope, if it identifies areas of concern, if the successor board does nothing else with that, at least it will help them with long-term planning and budgeting going forward.
All right, real quick, are you going to be talking about litigation issues for associations that have contractors that do a bad or an incomplete job? Sure, very quickly. That's just a claim. It's first, we would advise that you start out with a demand, whatever the issue is, that they either complete the work or pay you back the money that you gave them, something like that. But yes, absolutely. We have those lawsuits. We bring them against contractors. It's the same issue, though, that we mentioned before that you have to keep in mind. The 3-year statute of limitations applies, so you got to bring the suit within 3 years that you knew or should have known. And the 6-year statute of repose also applies because it's an improvement to real property. So yes, absolutely. You got to, you know, those are some of the cases, though, where usually it's small money and it might just be a demand letter, maybe, you know, without going all the way. But it's a cost benefit analysis depending on how bad the damages are.
And to that point, just because the board is the client and not the attorney, and the board is the one who's going to be driving these decisions. So the board doesn't have to pursue a case all the way to trial. The board might say, well, let's see if we can get anywhere with the 93A. Oftentimes, if the developer is responding to informal requests by the board, maybe the 93A demand is worth it because it at least forces the developer, arguably, to respond within the 30 days allowed under the statute, and get them to the table. And after that, the board might decide, you know what, we really don't want to pursue this further, and that's fine, as long as there's, you know, and as long as they don't let, you know, defects or deficiencies go unrectified. Just because they exist doesn't necessarily mean that it's in the best interest of the association to pursue, you know, a claim. It's about the net result, not about principle with these types of cases.
All right, here's a quick one. Can you structure a contract so the supervising engineer, I assume you mean the engineer hired by the board, can be sued along with the contractor? It seems that engineering firms, Peter, structure their contracts to absolve them for any contractor's failures. Well, I'll let Peter speak to this briefly, but I'll tell you that in my experience, I don't know any engineer who would work with a condominium without such a provision. Of course, the engineer who designed the project for the developer, that's different. Oftentimes, they actually are brought into those lawsuits. But if you're talking about the engineer hired by the association, I've never seen an engineer who would sign a contract without such a provision. Peter, go ahead.
Yeah, I think that's accurate, Tom. You know, in fact, we want to be engaged by the board directly, but we also want you know, the contractor, whether it be you know, third party contractor or whoever the case might be, they're also going to be engaged by the board. And you know, we're not going to we have those provisions in our contract and our terms and conditions such that we're not responsible for the contractor's means or methods or missteps.
Unless you're directly supervising, right? Or unless they're hired by you and engaged by you directly.
Right, and that's not something what we're tend on doing, is supervising these guys directly. We do as I mentioned, periodic inspections, but even then, there's we're not there every single day watching over them every single minute, and so there's an expectation there that we capture a lot, but we might not capture everything.
So that's why contracting, if you're going to contract for an engineer, a contractor, anybody, it's important that if you don't understand all the terms or you're concerned at all about recourse in the event of a breach, you should have an attorney review it.
All right, next is can developers be found liable and required to correct poor design decisions that are not defects per se, like selecting a garage door intended for individual residents, not mid-rise condo garage that fails frequently? Well, I would say failing frequently is a defect, first of all. So can the developer be forced to correct that poor design? No, you can't be that's a good question, because I get this a lot. To me, forced means going to court and getting a judge to order them to do something. No, I don't think a judge would order or could order a developer to fix a problem like that. What they can be forced to do is pay you money so that you pay someone to fix it. That they can be forced to do through a lawsuit. Short of a lawsuit, though, or trying to resolve it by agreement, there's no way to force them to pay you. So you have to take action. And I don't know, and other than by agreement, I don't know how there's any force against the developer to fix anything. Now, quick question. We should have pointed this out. Yes, you are. Will these slides be available? They're all going to be sent to you. There'll be a link where you can see the slides. Okay, so you'll have those available to you. Jen, we probably should wrap it up. There's still
so I want to invite anyone with questions, email me directly. And if you'd like copies of the slide presentation, please email any of us.
You can each email Julie, but I believe they're all going to be available to you. If you want to send us an email, you can, but check your emails to see if you've been given a link to the slides. And so many questions we didn't get to. Thank you for all the questions. They're really great.
I know, I wish I could answer all of them. That's why I'm saying I'm happy to respond if anyone wants to email me directly. My email is jbarnett, BARNETT @MEEB. That's MEEB.com. And I'll be happy to respond.
I won't go through my long email address, but it's on the first slide.
Yeah, or you can call us or direct,
or even on our website. You'll see.
Yeah, all of our information's on our website. Peter, I responded with your contact information as well. It's pbyrne@ccaco.com and 781-280-0660. Peter, is that the right number?
That's correct.
Great. So, and if you call our direct line, 781-843-5000, that's our main telephone number. You can be connected with Tom or myself. But we're sorry we went over. There's a lot of information.
It's a huge topic. Thank you for those who hung on. We really appreciate it.
Really appreciate it.
Maybe we'll have to do a follow-up. So
yeah, but this is a lot of information, and I think that's what we said in the beginning, that this is a daunting task, and it's overwhelming to even the most seasoned of individuals on the boards, but you don't have to go it alone.
Thank you, everybody. Thanks, Jen. Thanks, Peter. And we look forward to hearing from you. If you have any follow-up questions, and I think that'll do it. Thanks, everybody.
Thank you.
Thank you.
Bye-bye.